number 40, matter of Jordan versus New York City Housing Authority.
Jim, can I get some water?
Thank you. Thank you. Good afternoon, Counsel.
Good afternoon. May it please the court. Jane Littman from the New York City Housing Authority Law Department on behalf of Appellant NYCHA. I'd like to reserve 2 minutes of my time, please.
You may.
If allowed to stand, the decision and order of the Appellate Division, First Department, will upend the legislatively crafted balance of tenure rights in the civil service law.
Well, how do we get past just the word? I mean, employee doesn't have any limitation to it, right?
Yes, Your Honor. The legislative history of Section 71,
I guess the question is, why do we look to that?
because the point here is to ascertain and effectuate the intention of the legislature. And it is very clear from the legislative history.
So is your argument that even if the word is plain on its face and we know what the term means, that nevertheless we need to look at the legislative history?
Well, first of all, it's not the only word in the statute. There are other words, and those words must be considered when analyzing the word employee. Can't just look at the word employee and say, well.
I thought that was the crux of the argument, whether or not employees includes labor class employees.
That's correct, Your Honor. And to determine that question, one must look at the legislative history, as this court did in matter of Allen v. Howe.
But aren't you saying that there's other language in the statute itself that creates an ambiguity, and that is the reference to preferred lists and that sort of thing? Isn't that what gets you out of the statute to look at the legislative intent?
Yes, Your Honor. And our position is that it's not ambiguous because of those phrases which are statutory terms of art and specifically exclude the labor class. Now, when one looks at the legislative history of Section 71, as this court did in matter of Allen v. Howe.
Well, I disagree with your characterization of that legislative history. I know what Allen says, but if you look at the actual legislative history of 71 versus 73, and 73 is a very different statute. I think we talked about that in Allen. 71 says the purpose of protecting employees. 73 talks about Section 75.
Well, as this court discussed in matter of Allen v. Howe, and I think as is reflected in the legislative history.
Show me where in the legislative history of Section 71 they talk about the impact of Section 75.
The legislative history states that this is a new right, okay? So to give people rights under work, that for people who would need a leave under workers' compensation law.
Right.
Now, I mean, I think that you have to look also at the history of the civil service law.
But if we're sticking right now, forget the civil service law for a minute, as a general thing, it's 71, 73, 75. So 71 is workplace injuries, 73 is other injuries. They're different statutes. We said that in Allen, and 75 is certain rights relating to termination. And Section 73, when it's promulgated, and not that much later, talks extensively about the interplay between 75 and termination. 71, when it's promulgated, and 75 is out there, doesn't mention 75 at all in the legislative history.
Let me just point out that 71 was amended to add employees who were assaulted on the job. So in its original iteration, it just applied to.
Let me ask you this, Ms. Lippman. I think Judge Garcia makes a good point. So let's stay with the language of Section 71. Forget about the legislative history. Is there in the statute itself language that would indicate that you had to rely on that this is restricted to the competitive class in civil service, specifically like preferred eligible list, language like that would support your argument?
So preferred lists and preferred eligible lists are in Section 71.
All right. Now, those terms, what do they mean to you?
Okay, so those are clear indications that the labor class is excluded. Why? Because,
Well, let's forget about the labor class being excluded, because I don't know how clear they are, but let's just talk about the language itself. In the Section 71, they refer to the preferred list, the preferred eligible list, and there are only certain people that are qualified to be on those lists, and they are
the competitive class.
Right, in the competitive list. So I think that much of this case has been argued, and I really think Judge Garcia is right, much of this case has been argued on the legislative history of the case. And what I wonder is, really, you should have started with the language first, and that's why I'm asking you these questions. So respond to my point.
Okay, so Section 71 contemplates a couple of scenarios. The employee is reinstated to a lower grade position. That's one. There is no, and in that case, the employer is placed on an eligible list. Second scenario. There is no vacancy to which the employee may be reinstated. In that case, the employee is placed on a preferred list. Now, some very noteworthy points here. Labor class positions have no lines of promotion. There are no grades. So there is no lower grade to which a labor class employee may be reinstated. That's one. Two, eligible lists. Eligible lists are found in Section 50 of the Civil Service Law and connote a competitive class title. Why? Because an eligible list is composed on the basis of competitive examination rankings. Labor class employees don't take competitive examinations. Now, with respect to the preferred list, an employee is placed on a preferred list when there's no vacancy. Now, the definition of preferred list is found in Section 81, okay? Section 81 only applies to employees in Sections 80 and 88.
Doesn't the city use that term in its own regulation to refer to laborers?
Well, there is a DCAS regulation 6.5.5.
Do they not know the definition in Section 81?
This is a local DCAS regulation, okay, that gives the labor class Section 81 rights, which they don't otherwise have under the Civil Service Law. Now, again, this is a local regulation, a
So
DCAS.
couldn't 71 be doing that, giving them the right to be on a list which they wouldn't otherwise have under the Civil Service Law, if you could do that with a regulation?
Well, I think that we must distinguish the difference between a local rule, which may have arisen out of collective bargaining, and a statewide statute. I mean, presumably different municipalities have
If it
different.
works in that context, why wouldn't it work here?
Well, I mean, that is a DCAS regulation. I think DCAS would have to address that. That might be another reason why they're a necessary party. But as I said, these rights can be collectively bargained. We need to look at the statute, which has statewide effect.
Well, there's two things here. There are situations, aren't there, where the labor class employees have rights that are similar to the statutory rights you have, but they're the result of bargaining. What would the effect be if we were to say that this applied to them, not just were DCAS rules, but in every city throughout the state?
Well, I mean, to expand the civil service law like that is totally unwarranted. It would create tremendous administrative and financial burdens, and that has to be done by the legislature. It cannot be done by the court. So to allow, I mean,
Well, it
and
can be
actually.
done in one of two ways, I would think, statutorily by the legislature or by contract between the municipality and the contracting union, whatever the union is for the.
Correct, and as is reflected in the record in this case, this topic was the subject of collective bargaining between Local 237 and NYCHA. That's in the affirmation of Nicole Van Gant. Now,
But isn't one of the arguments, going back to Section 75, that 71, 73 were put in place because otherwise to terminate these employees would require some types of hearing and findings of misconduct or whatever, right?
yes.
And isn't that argument completely undermined by the addition of labor class employees to Section 75? So now if you've been a labor class employee for 5 years, you get the protections of Section 75 anyway.
Yeah, no, I don't think it's undermined at all, and I think it shows that when the legislature gives tenure rights to the labor class, they do so explicitly and
But
unambiguously.
don't you have the exact problem, at least for 5-year labor employees, let's say laborers who have 5 years on the job, you now have the exact problem you have that led to the enactment of 71, because you can't get rid of them without a disciplinary hearing now. Because you can't use 71, and you can't use 73.
I'm not sure I understand your question.
So, as I understand it, and I might be wrong, I thought Section 75 last year was amended. So now laborers with 5 years of experience get the protections of Section 75.
That's correct.
Which they didn't have before.
That's correct.
So doesn't that create for that class of laborers who have been working 5 years on the job the same problem that you had that led to the enactment of Section 71 and 73 in the first place, according to you, which is we can't get rid of these people without bringing disciplinary proceedings?
No, I don't think it does. I think that's conflating different concepts. I think the idea here is that
Doesn't Section 75 say that about laborers now who've been working for 5 years or more? That they can't be fired without they have certain protections before?
that's right. They have due process rights after 5 years. But I think that one mustn't conflate that with Section 71. So Section 71 addresses a situation where a covered employee, a competitive class employee, is injured on the job. Okay, they're allowed a year to convalesce, and then they are terminated. Okay.
Right, but what about a laborer who's been working for more than 5 years who is in that situation now? What happens?
They don't have Section 71 rights.
Right, so you have to bring some kind of misconduct proceeding to get rid of them. My point is, you were saying, I believed, that Section 71 and Section 73 were escape hatches from Section 75 because there were certain rights given regarding termination under Section 75 for certain classes of employees. And in order to terminate those employees, even if they had an on-the-job injury and had been out for a year, you had to follow these, so let's call them disciplinary proceedings under 75. But laborers weren't subject to 75, so why should they have been included in 71? But now, laborers are included in Section 75 if they've been on the job for 5 years or more. So don't you have the same problem for laborers who've been on the job 5 years or more, who are injured on the job or are out more than 1 year?
No, I mean, if they're out more than 1 year, they would be terminated pursuant to a Section 75 disciplinary proceeding, or their leave could be extended potentially.
That was exactly what Section 7, I thought the position of the briefs was exactly what Section 71 was meant to avoid.
Yes, but I think that you have to keep in mind that the competitive class is a protected class under the civil service
So
law.
are laborers now who have worked for 5 years or more.
But I thought your other argument was if the legislature wants to go farther, it does that and may do it piecemeal, may not want to do it all at once, and it hasn't done it comprehensively here. I thought that was part of your
I
argument.
mean, I think that that's right. I mean, and actually, what they did in Section 75 shows that when they want to give tenure rights to the labor class, they do it explicitly. They can do that with Section 71. They have it.
But assuming on your theory that 71 and 73 were essentially cross-referencing 75 and the protected classes within 75, isn't there an argument the legislature thought, like a cross-reference, we amend 75, we amend the other two?
I think we have to look at the legislative intent in 1958 when Section 71 was enacted. I don't think we could say, well, the legislature amended Section 75 last year, therefore we go back and we change how we were thinking about Section 71. When the legislature enacted Section 71 in 1958, the labor class was at will. That is when we have to interpret the statute. And at that time, the legislative history shows that it was not thought to be appropriate to bring a stigmatizing disciplinary proceeding to terminate and replace an absent disabled employee. We must look at 1958, not what happened afterwards.
Well, that goes to, I think, the first discussion we were having, which is in 1958, no one mentioned 75. All they mention is protection of workers. And then it's only in Section 73, which is years later, that they mention 75.
Okay, but if we look at, for example, matter of Merriweather versus Roberts, which is a case that was discussed at length in the city's amicus brief, and we touched on it. This court held that the tenure protections of the civil service law were intended to shield competitively tested employees and were not intended to protect any person in the civil service. That is the background of this law. We have to look at 1958 when it was enacted.
Counsel, move to the mandamus issue for a moment. What is the process by which DCAS can accomplish delegating its authority to conduct the medical examinations?
Well, first of all, that did not happen in this case, but there is a city charter provision, Section 814B, that allows the commissioner of DCAS to delegate certain personnel responsibilities to the head of an agency. Now, the record in this case reflects that that did not happen here. There's an email chain between an assistant DCAS commissioner and the head of HR, the NYCHA head of HR, who is not the head of NYCHA. And in that email chain, DCAS confirmed for NYCHA, as it had done previously in a phone call, that sections 71, 72, and 73 have no application to the labor class.
Thank you, counsel. Counsel?
Good afternoon, Josh Ellison for respondents. I appreciate the court's interest in looking at the text of the statute, and I think that it's important to note that the statute, section 71, says that an employee will be placed on a preferred list. It doesn't say the preferred list. It doesn't say the preferred list referenced in section 71.
But how is preferred list defined in the statute?
Well, preferred list isn't defined
Not
in
in
the
this
statute.
particular section, it isn't, but isn't it in the overall statutory
A
scheme?
preferred
Yeah.
eligible list.
Okay.
That's what applies to competitive class employees.
Counsel, do you have any examples of labor class employees for whom a preferred eligible list was established?
No, I don't believe there are any preferred eligible lists, but I believe section 71 establishes a preferred list.
Okay.
An eligible, so
Any with respect to a preferred list?
well, I believe section 71
Well,
establishes
I
such a
think the
list.
chief is asking you, can you give an example of a labor job where there is a preferred list for that job?
No, not that I'm aware of.
Okay, and the language in the statute says a preferred list for his or her former position.
Correct.
Doesn't that create a problem?
Well, I believe the effect of the statute here is to create, this would create a preferred list. If you have multiple employees who are put out in this situation, because these are laborers, they do heavy physical work, they are more likely than any other class to,
How would they establish such a list if there's no competitive exams?
well, I believe the first out, first back would be the,
Well,
would be how
where
it
does
would
it
work.
say that?
Well, it doesn't. I believe it's left, there's, there's.
Would you establish it by contract?
It could be established by contract.
I thought that was a normal practice. It's established by contract. It's an item of negotiation, isn't it?
Well, it could be, I don't believe that the negotiation could provide how that, also believe in this case DCAS, this local civil service, could
You can
promulgate
correct me, because you
regulations.
probably know this better than I do, but I thought the process was, after the person's hired, if something happens like this, they go off, first out, last back, then applies. But in the initial hiring, they're not done off a list, and that the seniority on hiring, rehiring after an injury is governed by contract.
It can be. It doesn't necessarily need to be
I see.
governed by contract. There's certainly the union and the employer could negotiate a procedure for separation and rehire, but I don't believe that that's necessary.
That isn't based on seniority?
It could be. It could be first. It could be.
Okay, so
based
then
on
you're
anything.
saying the statute gives no guidance?
I'm saying I believe the statute is silent as to how to establish the preferred list.
Okay, so who or to what is the legislature delegating the authority to define the parameters of the list?
I believe it would be the Civil Service Commission with jurisdiction over that title.
Don't you need statutory guidance to do that? Otherwise, it's an inappropriate delegation of authority.
Well, I don't believe so. I think that under the civil service law, the local or municipal civil service commission has jurisdiction over all administration of the civil service law to the extent it isn't directly conflicting with the statute.
If a labor class employee goes out on disability and then wants to come back and let's just assume for a moment, is entitled to the protections of Section 71, and then they get on this list and then they get rehired, and they're not subject to the new tenure provision. So then could they be fired the next day?
Well, I think they would be subject to the next tenure provision.
Well,
to the new
let's say
tenure
let's say they
provisions.
weren't there for 5 years.
Let's say, okay, sure,
Okay.
certainly.
So there were no entitlement to tenure. So then you set up this whole process, they get the right to come back, and then what protection do they have from not being fired the next day for no reason?
I believe they would be subject to termination the next day, but I don't think
So
that
would the legislature establish that kind of process?
Well, I don't think the legislature would anticipate that a municipal employer would simply discharge someone for no reason. That if they were hired back, that they would presumably
Well,
continue
if
to.
they were hired back because they were forced to hire them back because of this statute, particularly if you're basing it on on seniority rather than on any kind of merit.
Well, if there's a vacancy, I would think that the municipality would need them. So I
Yes,
don't.
but they might not need the very next person on this supposed list, right? They might think, I don't want that person. That person's not been a good worker. I want the fifth person down.
Well, I think.
What prevents them from hiring them, under your scenario, hiring them, firing them, going through that until they get to the employee that they want?
Nothing in the statute would prevent them from doing that, but I think that would be
Doesn't that
an
then-
irrational thing
But
to
doesn't
do.
that sound like an absurd result that the legislature could not possibly have intended with this, with your interpretation of the statute?
Well, I think it would be an absurd thing for the employee to do if they wanted to hire them back and then fire them for incompetence.
Well, if they wanted to hire them back, you wouldn't need Section 71 at all.
Right, if they were forced to hire them back and then fire them for incompetence, then there would be no,
Or for no cause?
or for no cause.
Counsel,
But
today, if same facts, but the termination was going to happen today, could they do this to your client? She's more than 5 years, right?
yes,
So could they terminate her?
no,
Right.
not without the protections of,
And so essentially, if Section 71 doesn't apply to her, the only way they could terminate her would be through some type of Section 75 proceeding.
Correct.
Today, right?
correct.
And if this did apply to her, same thing today, and she gets on a list and she gets back on, they couldn't fire your client because she has more than 5 years, right?
Correct.
So they couldn't fire your client the next day.
Correct.
Because she has more than 5 years, she has Section 75, right?
Right.
Well, they'd have to go through a process.
They would have to go through, yeah, they could fire her if they could prove that she
She might not have
engaged
to
in
be
misconduct.
rehired
She might, if there's no vacancy.
at the end of that process.
If there's no vacancy after the medical determination. And I would just like to point out that the court's decision in Merriweather from 1935 was interpreting a version of the civil service law before it was recodified and expanded in 1958 to grant greater protections to all sorts of classes. So I don't think that decision is very informative as to how Section 71 should be interpreted. And if that's all, I will rest.
Thank you,
Thank you.
counsel. Counsel, rebuttal?
Okay, I want to go back to Judge Garcia's point about legislative history. And I want to point out that we did cite some legislative history in both of our briefs. There's a memo from Christopher Boyling, this is in the record. Section 71 allows a person who would otherwise be terminated without a right to reinstatement to have an ability to be reappointed without having to seek a new job through civil service testing and appointment from an open competitive list. So one important point, really important point to remember here, is that reinstatement rights are, as a practical matter, are really only necessary for the competitive class. Why? Because they have to take an exam. They have to undergo an appointment process, okay? The labor class, until very recently, was at will. They didn't have to take any exam. So I think you have to look at Section 71 both through the sort of the prism of terminating the person
The
and hiring them.
non-competitive class isn't hired either, under your view. The non-competitive class is not covered under Section 71. Only the competitive class is covered.
I think that definitely the competitive class.
And what about non-competitive?
Definitely not labor. Non-competitive, I think, is at least state non-competitive, I would say, is arguable because they may be placed on a preferred list. And I think that that language is absolutely critical. These are statutory terms of art. You know, Section 71 doesn't say list. It gives no basis for departing from the very specific statutory meanings of preferred list and eligible list. And those phrases exclude the labor class. I just want to quickly respond to another point my opposing counsel made. He said laborers are more likely to be injured on the job. The competitive class includes police officers, firefighters, nurses, all of the skilled trades. NYCHA employs thousands of them. So anyone who gets injured on the job can get workers' compensation. This is a special right for a protected class. I think that's very obvious in the legislative history, the civil service law, the background of it. It was not intended for laborers. And by the way, the legislative history says laborers. It does not say employee.
Thank you, Counsel.
Thank you very much.